If you were married for 10 years or more before your marriage ended in divorce, I need you to understand something that most financial advisors will never tell you, and that the Social Security Administration will not bring up on its own unless you specifically ask. The United States government may owe you a Social Security benefit worth hundreds or even over $1,000 every single month for the rest of your life. And the vast majority of divorced Americans who qualify for this benefit are simply not collecting it because nobody ever explained that it exists. Today, I'm going to change that. I'm going to walk you through the divorced spouse Social Security benefit from start to finish. I will explain the 10-year rule, show you exactly how much you could receive, cover every eligibility requirement you need to know, explain what happens if your ex-spouse has already passed away, and give you step-by-step instructions for claiming what is rightfully yours. Let me start with the most basic and important concept, which is the 10-year marriage rule. The divorced spouse Social Security benefit is available to any person who was married to their former spouse for at least 10 consecutive years before the marriage legally ended in divorce. 10 years is the threshold. 9 years and 11 months does not qualify. 9 years and 364 days does not qualify. But if your marriage lasted at least 10 full years, you are potentially entitled to a Social Security benefit based on your ex-spouse's lifetime earnings record, regardless of whether your ex has remarried, regardless of whether your ex even knows you're applying, and regardless of anything your divorce settlement said about financial matters. Before I go any further, I want to address the question that almost everyone asks when they first hear about this benefit. Will this hurt my ex-spouse in any way? Will their monthly check be reduced? Will they be notified? The answer to all three questions is no. Your divorced spouse benefit is entirely separate from whatever your ex-spouse is receiving. The Social Security Administration pays it independently. Your ex-spouse's benefit is not reduced by 1 cent. They are not required to consent to your application. They may or may not be notified depending on circumstances, but in no case does your claim affect their income or their benefits. This is a benefit you have earned by virtue of being part of a 10-year marriage, and it belongs to you. Now let me explain how much you can actually receive. The divorced spouse Social Security benefit is worth up to 50% of your ex-spouse's full retirement age benefit. Note that this is 50% of the full retirement age amount, meaning the benefit your ex-spouse was entitled to at age 67, not necessarily 50% of what they are actually collecting, if they claimed early or are collecting a different amount. Let me put real 2026 numbers to this so you can see what this could mean for your retirement income. Suppose your ex-spouse worked for 35 or 40 years in a well-paying professional or trade career. Their full retirement age, Social Security benefit is $2,600 per month. 50% of $2,600 is $1,300 per month. That is $1,300 every single month deposited into your bank account for the rest of your life. Over 12 months, that is $15,600 per year. Over 20 years of retirement, that is $312,000. Just from a benefit that millions of divorced Americans are currently leaving uncollected because they did not know it existed. Now, there is one important clarifying rule about how this benefit interacts with your own Social Security record. If you worked during your career and built up your own Social Security retirement benefit, the SSA will compare your own earned benefit to the divorced spouse benefit you are entitled to. Social Security pays you the higher of the two amounts. They do not pay both. If your own earned benefit is already higher than 50% of your ex-spouse's full retirement age benefit, you simply receive your own benefit and the divorced spouse entitlement does not apply. But if your own benefit is lower, Social Security tops you up to the divorced spouse level. This is called a spousal add-on, and it ensures you receive the maximum amount you're entitled to. Beyond the 10-year marriage requirement, there are other eligibility rules you need to meet. You must be at least 62 years old to start receiving divorced spouse benefits. Just as with regular Social Security, claiming at 62 means you receive a reduced amount compared to waiting until your full retirement age of 67. If you claim the divorced spouse benefit at 62, it is reduced by approximately 30 to 35% compared to the maximum 50% you would receive at full retirement age. If you are able to wait until 67, you receive the full 50%. Unlike your own Social Security benefit, there is no additional bonus for waiting past 67. The divorced spouse benefit maxes out at full retirement age and does not increase further by waiting until 70. So 67 is your optimal claiming age for this particular benefit if you can wait. You must also currently be unmarried to claim on your ex-spouse's record. If you have remarried, you are not eligible to claim on your former spouse's record. However, if that later marriage ended in divorce or your subsequent spouse passed away, your eligibility to claim on your original ex-spouse's record can be restored. The Social Security rules on remarriage and eligibility restoration are specific, so if you have had multiple marriages, it is worth talking to SSA directly about your particular situation. Regarding your ex-spouse's own claiming status, the rules differ depending on whether your ex has already filed for their own Social Security benefits. If your ex has already started collecting, you can apply for your divorced spouse benefit at any time after you turn 62. If your ex has not yet claimed their own Social Security, you must have been divorced for at least 2 full years before you can claim the divorced spouse benefit on their record. This 2-year waiting period after divorce was designed to prevent marriages entered into specifically to access spousal benefits, and it applies only when the primary earner has not yet started their own Social Security. Now, I want to cover something that very few people know about, and that can be significantly more valuable than the standard divorced spouse benefit. What happens if your ex-spouse has already passed away? If your former spouse has died and you were married for at least 10 years before divorcing, you may qualify for what is called the Divorced Spouse Survivor Benefit. And this benefit is substantially more generous than the standard divorced spouse benefit. As a surviving divorced spouse, you can receive up to 100% of your ex-spouse's Social Security benefit. Not 50%, 100%. The exact same survivor benefit that a current widow or widower would be entitled to receive. The requirements for the divorced spouse survivor benefit are very similar to the regular divorced spouse benefit. Your marriage must have lasted at least 10 years. You must currently be unmarried, with an exception for remarriage after age 60. If you remarried after reaching age 60, you may still qualify for the divorced spouse survivor benefit on your prior ex-spouse's record. You must be at least 60 years old to collect the survivor benefit, or 50 years old if you are disabled. If you are a divorced person whose former spouse has passed away and you meet these requirements, please contact the Social Security Administration immediately. Many divorce survivors are entitled to significant monthly benefits they have never applied for. Here is the step-by-step process for claiming your divorced spouse benefit. First, gather the documents you will need before you contact SSA. You will need your own Social Security number and birth certificate. You will need your marriage certificate showing the date your marriage began. You will need your divorce decree showing the date your marriage ended. And you will need either your ex-spouse's Social Security number or enough identifying information such as their full name and date of birth for SSA to locate their record. Second, contact the Social Security Administration. You can apply online at ssa.gov. Call SSA at 1-800-772-1213 or visit your local Social Security office in person. Third, when you apply, specifically tell the SSA representative that you are applying for divorced spouse benefits and that you want them to check your entitlement to benefits based on your former spouse's earnings record. Do not assume SSA will check this automatically. Be explicit about it. Fourth, apply as soon as you are eligible and ready. Social Security benefits generally cannot be paid retroactively for more than 6 months before your application date. If you are eligible today and wait 6 months to apply, you lose 6 months of benefits that you cannot recover. Please do not delay. If this video opened your eyes to a benefit you were not aware of, please share it with every divorced person you know who is married for 10 or more years. The number of Americans who qualify for this benefit and are simply not collecting it is staggering. Subscribe to this channel for more Social Security strategies every week. My next video is going to cover the Social Security break-even calculation, which is the mathematical answer to the question everyone eventually asks, when does waiting to claim actually pay off? I'm going to show you the exact numbers, the exact break-even ages, and how to calculate your own personal answer. Subscribe so you do not miss it. Thank you for watching.